Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. With the introduction of Bill C-63, the Online Harms Act, in Parliament just over a month ago, there's been a lot of discussion about the part of it that was a big surprise, namely the amendments to the Criminal Code related to hate crimes and the proposed amendment to the Canada Human Rights Act. If these provisions become law, I'm sure they will no doubt be challenged as an infringement of the freedom of expression right under our Charter of Rights and Freedoms. That's just how laws work. If anyone is charged with a crime that affects expression, it's 100% expected that the law will be challenged. I personally think there are pervasive misunderstandings about hate crimes in the law in Canada. Bill C-63 will surely make some changes, but we have existing crimes in Canada connected to hate speech. It needs to be understood that hate speech is not speech that someone in authority hates. Hate speech is not itself a crime. So what I plan to do in this discussion is to go through the existing hate crimes in our criminal code and look at how they've been reviewed by the courts in light of the Canadian Charter of Rights and Freedoms. While I have some opinions on the subject, I'm going to be as clear and as straightforward as I can be. Just the facts, or I guess just the facts and the law. The existing hate crimes that we have in our criminal code are advocating genocide, the public incitement of hatred, the willful promotion of hatred, and a new offense, the willful promotion of antisemitism. The first one we'll look at is advocating genocide in Section 318 of the Criminal Code. It was first added to the Criminal Code in the 1960s. The offense reads, every person who advocates or promotes genocide is guilty of an indictable offense and liable to imprisonment for a term of not more than 5 years. You'll note that I've crossed out for a term of not more than 5 years and I've replaced it with for life. This is one of the proposed amendments in Bill C-63, so the maximum punishment for advocating genocide is now life in prison. Subsection 2 contains the definition of genocide for the purposes of this section and the offense. It says in this section, genocide means any of the following acts committed with the intent to destroy in whole or in part any identifiable group, namely killing members of the group or deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. Identifiable group is defined, though I won't read it. You'll have to note that subsection 3 reads, no proceeding for an offense under this section shall be instituted without the consent of the Attorney General. This means that the provincial or federal Attorney General would have to approve of and consent to the laying of the charges. This is generally intended to be a check on the possible overuse of the section. To my knowledge, there have not been any recent prosecutions for advocating genocide. In order to be found guilty of advocating genocide, the Crown would have to prove that the accused actively had, as their conscious purpose, advocating for or promoting the death or physical destruction of the identifiable group. That's a pretty high bar. The next offense we're going to look at is the public incitement of hatred in Section 319 sub 1. The offense reads, everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace is guilty of blah, blah, blah. Though you'll note that Bill C-63 proposes to increase the maximum possible sentence from 2 years to 5 years in jail. This section also includes some definitions and will be supplemented by a new term, hatred, to be added by Bill C-63. Which says hatred means the emotion that involves the detestation or vilification and that is stronger than disdain or dislike. So what does this mean? As I often tell my law students, we have to look very closely at what Parliament has included in the offense, called the essential elements, what can be captured by the offense, and also what has been excluded. In order to obtain a conviction, the Crown would have to prove, among other things like identity, first, that the statements were made in a public place. So this is not a private home or as part of a private conversation. It would likely include online social media provided it was sufficiently public. Second, the statements have to incite hatred towards a group. And this is where the Charter comes into play in a big way, which I'll discuss shortly. Number 3, the group has to be an identifiable group per the definition. And the incitement has or is likely to lead to a breach of the peace, which is more than just turning the audience over to your point of view. The Supreme Court has said that an act can be considered a breach of the peace only if it involves some level of violence and a risk of harm. Behavior that is merely disruptive, annoying, or unruly is not a breach of the peace. And then finally, the culprit knew or was willfully blind to the likelihood of the incitement leading to a breach of the peace. So this only applies in scenarios like a rally where somebody promotes and incites hatred against an identifiable group where the speaker would or should expect that mayhem, rioting, violence, or physical harm would result. This would not cover simply saying something hateful online. It would have to incite hatred and be likely to lead to a breach of the peace. The next hate crime offense is the willful promotion of hatred contained in Section 319 sub 2 of the Criminal Code. It says everyone who by communicating statements other than in private conversation willfully promotes hatred against any identifiable group is guilty of yada yada yada. Though you note also that Bill C-63 proposes to increase the maximum possible sentence from 2 years to 5 years in jail, as with the public incitement of hatred. So let's look at what is in and what is out with this offense. In order to have a conviction, the prosecution has to prove beyond a reasonable doubt that the accused communicated statements, the communication was not in private conversation, the accused willfully promoted hatred against an identifiable group. This is obviously broader than the offense under Section 319 sub 1, the public incitement of hatred. It doesn't have to be in a public place, but private conversation is excluded. It doesn't have to lead to a risk of breaching the peace. There are also a number of defenses to the willful promotion of hatred, which clearly are there to protect certain forms of expression. This offense and the public incitement of hatred offense both, of course, turn on the idea of hatred. What does that mean, and how does that fare when it comes up against the Charter-protected right to freedom of expression? All the case law on this is obviously before the new definition of hatred to be added to Bill C-63, but I don't think it changes much, as we'll see. The new definition itself actually comes straight from the case law. Contrary to some things said online, statements that promote or incite hatred are Charter-protected expression. Anything that expresses meaning short of violence or threats of violence is Charter-protected. The question is whether they can be criminalized in a manner prescribed by law that is consistent with our free and democratic society. The Supreme Court of Canada considered this in a 1990 case called Keegstra. A split court decided that the Criminal Code's provisions related to the willful promotion of hatred could survive charter scrutiny if hatred was strictly construed. Chief Justice Dixon wrote for the majority, saying, "In my opinion, the term hatred connotes emotion of an intense and extreme nature that is clearly associated with vilification and detestation." You'll note that the words detestation and vilification can be found in the new definition proposed by Bill C-63. Chief Justice Dixon then goes on to write, quote, "Hatred in this sense is a most extreme emotion that belies reason. An emotion that if exercised against members of an identifiable group implies that those individuals are to be despised, scorned, denied respect, and made subject to ill treatment on the basis of group affiliation." Justice McLaughlin wrote the minority dissenting decision using a more dictionary sort of definition of the word and would not have concluded that it would pass charter scrutiny as being minimally impairing. She was also concerned about the chilling effect on freedom of expression. Overall, I think it probably has had a chilling effect, mainly because of continuing confusion about the legal meaning of the word hatred. The Supreme Court of Canada in 2013, in a case called Saskatchewan Human Rights Commission and Whatcott, had the opportunity to consider hate speech provisions in the Saskatchewan Human Rights Act. The court said, quote, "Restricting expression because it may offend or hurt feelings does not give sufficient weight to the role expression plays in individual self-fulfillment, the search for truth, and unfettered political discourse. Prohibiting any representation which, quote, ridicules, belittles, or affronts the dignity of, unquote, protected groups could capture a great deal of expression, which, while offensive to most people, falls short of exposing its target group to extreme detestation and vilification, which risks provoking discriminatory activities against that group. Rather than being tailored to meet the particular requirement, such a broad prohibition would impair freedom of expression in a significant way." When I hear discussion about this, most people understand the word hate and hatred in the dictionary sense, and not in the way that it was defined by the Supreme Court. I think this has led to a lot of confusion. We also have the new offense of willful promotion of antisemitism, which was added to the Criminal Code in 2022. I haven't seen any cases that discuss this, so it remains to be seen how the courts will approach this offense. I can't help but note that I haven't seen any laws before that use the term downplaying. This offense also has a number of defenses which are largely similar to the defenses to the charge of willful promotion of hatred. It's worth noting that in the Keegstra case, Among the statements that were seen as the willful promotion of hatred was his Holocaust denial, and much of his ranting was anti-Semitic. It is unfortunate that a lot of the arguments going on now, driven by Bill C-63, are based on an inaccurate understanding of how the courts deal with the concept of hatred and how that intersects with the right of freedom of expression under our Charter of Rights and Freedoms. While I've tried to keep my own opinions out of this, I will say that I think it was phenomenally dumb of the current government to tie the Criminal Code and Human Rights Act amendments to Part 1 of the bill dealing with online harms. This should have been a separate bill. Because of all the controversy associated with this, we're losing the opportunity for clear, good faith conversation on two different but related important issues. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics that I might cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.